"I'm not finished, Your Honor." The words cracked through the federal courtroom like a sudden lightning strike. Judge Gregg Costa's hand froze mid-gavel, the soundless pause louder than any verdict. All eyes shifted toward Congresswoman Jasmine Crockett as she rose from the witness table, her hand tightening around a worn, leather-bound binder, the kind that suggested preparation measured not in hours, but in battles fought. "With all due respect," she continued, her voice steady, her tone sharpened with the kind of resolve that doesn't tremble even under the weight of a federal bench. "You've spent the last 20 minutes questioning my grasp of precedent, but it's page 47 of your own ruling, dated 2019, that contradicts everything you just claimed." The silence that followed was suffocating. The courtroom, packed wall to wall, gasped as though one breath had been pulled from every chest at once. Judge Costa, a man whose reputation was carved in stone as an intellectual force and master of control, faltered. His face, once framed in the assured composure of authority, betrayed a flicker of shock. The courtroom's imbalance of power had tilted. Crockett didn't blink. She pressed forward, her eyes locked on his. "Perhaps," she said deliberately, "we should read it aloud. Let the record, and everyone hear exactly what you wrote." The tension in courtroom 3 swelled to breaking point. Spectators leaned forward. Clerks stopped mid-note. And for the first time in years, one of the most formidable judges on the Fifth Circuit sat in silence, disarmed by his own words, retrieved and wielded by someone bold enough to challenge him on his turf. What happened next didn't just alter the trajectory of this hearing, it reshaped the story of who controls the truth inside America's courtrooms. And it proved that even federal judges, men trained to wield words like weapons, can be cut down by their own blade when confronted by someone who's done their homework. This isn't just legal drama, it's power meeting preparation. And if you think this moment is explosive, wait until you see what came after. Hit that subscribe button and ring the bell right now, because the story unfolding here doesn't just matter for one courtroom. It matters for the future of justice itself. The Fifth Circuit Court of Appeals in New Orleans looms like a fortress of marble and authority. Its cavernous ceilings, dark wood-paneled walls, and echoing chambers have absorbed decades of legal warfare. But few mornings carried the electricity that charged the air on that Tuesday. The case at hand centered on voting rights legislation, specifically the constitutionality of new restrictions placed on early voting across several southern states. On paper, it was another in a long line of legal showdowns. In practice, it became one of the most unforgettable confrontations of the year. At 52, Judge Gregg Costa had built his reputation as a towering figure on the bench. Appointed to the Fifth Circuit by President Obama in 2014, he had already cemented his name in legal circles as a prosecutor who dismantled financial giants. He led the Enron task force, securing convictions in some of the most notorious fraud cases in American history. Costa's judicial persona was legendary, relentless, razor-sharp, a man whose mind was both a scalpel and a sledgehammer. He was known to pepper seasoned attorneys with rapid-fire questions, designed not merely to clarify arguments, but to expose weaknesses with surgical precision. Legal blogs warned litigants the way sailors warn of storms: prepare for Costa, or you will drown. Armed with degrees from Dartmouth and the University of Texas School of Law, Costa brought academic ferocity to his courtroom. His opinions were cited with reverence in law reviews. Clerking for him was considered a golden ticket into the upper echelons of legal practice. "Judge Costa doesn't suffer fools," said Miranda Johnson, a former clerk. "He expects preparation at a level most can't fathom. He remembers everything, reads everything, and he will use that knowledge to dismantle you if you come unprepared." That Tuesday morning, however, Costa found himself in uncharted territory. He wasn't dismantling. He was being dismantled, and the courtroom could feel it. Judge Gregg Costa's sharpness on the bench had often been compared to a scalpel during questioning, precise, cutting, and almost surgical in the way it exposed weaknesses. What made him truly formidable, though, wasn't just the sharp edge of his intellect. It was the breadth of his experience. Before donning the robe, Costa had stood on both sides of the courtroom, prosecutor and defense attorney. He knew how to dismantle a case from multiple angles. He didn't just anticipate arguments. He preempted them, slicing into an opponent's reasoning before they even had the chance to voice it. That mastery of the law had silenced countless witnesses over the years. And in the weeks leading up to this hearing, many expected nothing less. Costa had already circulated a preliminary opinion suggesting skepticism toward expanded early voting provisions. He hinted that such measures might clash with equal protection principles, a signal to legal observers that he was prepared to grill anyone defending the legislation. What Costa couldn't have anticipated was who would be sitting at the witness table that morning. At 43, Congresswoman Jasmine Crockett embodied a new chapter in American politics. Before she became one of Texas's rising stars in the House, she had built her career in the trenches of civil rights litigation, particularly voting rights. Her path hadn't been polished by elite firms or backroom political connections. Raised in St. Louis, Missouri, Crockett had worked multiple jobs just to put herself through Rhodes College, and then the University of Houston Law Center. When most law graduates chased lucrative partnerships at prestigious firms, she chose a different path. She opened a modest practice and began taking on the cases no one else wanted, the ones too messy, too underfunded, too politically sensitive. Her old law partner, Carlos Ramirez, once explained what set her apart. What most people don't get about Jasmine is that her memory isn't just photographic, it's weaponized. She doesn't just recall cases, she internalizes them. She can walk into a courtroom and recite citations page by page, like she's pulling the words right off the documents. That gift, combined with relentless preparation, had defined her rise in Congress. Where many freshman representatives floundered in the labyrinth of procedures and obscure rules, Crockett thrived. She didn't just sponsor bills. She mastered them, dissecting their constitutional implications, tracing their historical roots, and anticipating every possible legal challenge. Her meticulousness wasn't abstract. It came from experience. Before entering politics, she had argued before Judge Costa twice, winning once, losing once. Those encounters had left a mark. She had studied his methods, his fixation on precedent, his impatience with emotional appeals, and most of all, his peculiar habit of returning again and again to his own past rulings as anchors in his logic. The night before the hearing, Crockett addressed her staff with quiet clarity. "I respect Judge Costa's intellect tremendously, but respect doesn't mean deference. Not when constitutional rights are on the line. He's going to come at me hard on precedent and jurisdiction. We need to be ready for that." What Costa didn't know was that Crockett had already prepared in ways that bordered on obsessive. For a full week, she had pored over every single voting rights opinion Costa had written in his 8 years on the bench. All 37 of them. She didn't skim, she dissected. Line by line, page by page, hunting for patterns, contradictions, even the smallest fractures in his reasoning. And tucked inside that mountain of rulings, she found what she was looking for. An inconsistency so striking that when the moment came, she could unsheath it like a blade. It would be the detail that silenced the judge who never lost control of his courtroom. Contradictions cataloged, rulings dissected. Her preparation was complete. The stage was set. This wasn't just another hearing. It was a collision between two legal forces: a federal judge long accustomed to absolute command in his courtroom, and a congresswoman who had built her career refusing to yield when power tried to silence her. Have you ever witnessed someone in authority confronted with their own words, forced to hear them echoed back in public? How did they respond? Think about that, and share your experience in the comments, because what unfolded in this courtroom was exactly that kind of reckoning. The morning began with ceremony. The clerk's voice rang out, calling the case. Counsel rose, names were read into the record, and Judge Costa, flanked by two other Fifth Circuit judges who would remain largely spectators in this drama, cleared his throat and spoke. "We are here today to consider constitutional challenges to the Expanded Voting Access Act," he began. His voice carried the measured weight of authority, each syllable deliberate, as though engraved in stone. "We will hear testimony from several members of Congress regarding legislative intent, though I remind everyone present that intent, while informative, is not determinative of constitutionality." The first two witnesses, both male co-sponsors of the legislation, endured sharp questioning, but nothing outside the bounds of routine appellate inquiry. They left the stand with reputations intact, though noticeably rattled. Then Congresswoman Jasmine Crockett was sworn in. As she adjusted the microphone and settled into the witness chair, the atmosphere in the room shifted. Those who knew both Costa and Crockett could feel it, the anticipation of a duel, not of raised voices, but of sharpened minds. "Congresswoman Crockett," Costa began, his tone crisp, deliberate, almost predatory. "You are not only a legislator, but an attorney, correct?" "Yes, Your Honor," Crockett replied, her posture firm but respectful. "I practiced civil rights law for 12 years before my election, specializing in voting rights cases." Costa's eyes narrowed, the faintest nod betraying recognition. "Then you are no doubt familiar with the Supreme Court's decision in Shelby County v. Holder, which struck down the federal preclearance requirements for changes to state voting procedures." "I am intimately familiar with that ruling, Your Honor," Crockett answered evenly. "In fact, I served as counsel on 3 subsequent cases in Texas that dealt directly with its consequences." Costa leaned forward now, his voice tightening like a spring. "Then perhaps you can explain how Section 4 of your legislation does not, in effect, reinstate the very preclearance formula the Supreme Court explicitly rejected." And with that, the duel began. For the next 15 minutes, the courtroom watched as Costa launched volley after volley of rapid-fire questions, each one crafted to corner her. Challenges on constitutional authority, interrogations of precedent, technical dissections of jurisdictional scope. Most witnesses wilted under this pace. Crockett did not. "Your Honor," she said steadily, "Section 4 does not reinstate the rejected formula. It establishes a new standard, one rooted in contemporary evidence of discrimination, documented by recent cases across multiple jurisdictions. It is a forward-looking framework, not a recycling of the past." Costa pressed harder, quickening the rhythm. "But isn't Congress, in effect, attempting to reassert powers that the court has already limited? Doesn't this represent legislative overreach into areas reserved for the states?" Crockett didn't flinch. Her eyes remained steady, her words precise. "Respectfully, no, Your Honor. The Constitution empowers Congress to enforce voting rights protections. What this legislation does is apply that authority to modern conditions, not historical ones. It acknowledges the court's ruling while responding to current evidence of systemic barriers." The audience leaned forward, silent, riveted. This was not testimony anymore. This was a chess match at the highest level. Each move, each counter, pulling the room deeper into the confrontation everyone had been waiting for. And beneath the calm of her answers, one truth lingered. Crockett was waiting. waiting for the precise moment to unveil the contradiction she had found, buried in Costa's own words. The one detail that would shift the power dynamic of the entire courtroom. Since 1998, which the legislative record demonstrates have predictive value for ongoing discrimination, Crockett concluded, her tone firm. Costa shook his head slightly. But the court was clear, Congresswoman. The formula must reflect current conditions, not historical patterns. Your new standard still relies on past violations. With respect, Your Honor, Crockett countered, leaning forward just enough to command attention. Shelby County specifically affirmed Congress's authority to draft a new coverage formula based on current data reflecting current needs. That's exactly what we've done. The record is unambiguous. The violations since 1998 provide a present, ongoing predictor of discrimination, not relics of the past. The room was silent but electric. Costa pressed harder, his voice tightening with each new question. Crockett parried with precision, citing cases, quoting rulings verbatim, drawing sharp lines between precedent and practice. The other judges on the panel exchanged glances. They weren't just observing a witness anymore. They were watching a legal debate between equals. Then Costa shifted his footing. No longer purely technical, his words took on a sharper edge, a challenge rooted in philosophy rather than precedent. Congresswoman, he began, you've spoken at length about expanding access to the ballot. But the Constitution doesn't guarantee convenience in voting, only that the right itself not be denied or abridged. Doesn't your legislation conflate these two distinct concepts? A trap. Crockett recognized it instantly. She let the pause stretch, her silence commanding as much as her words. Then, carefully, Your Honor, I don't accept that those concepts are distinct in practice. When early voting locations are removed from minority neighborhoods while expanding in predominantly white areas, that's not a matter of convenience. That's a functional abridgment of the right to vote. Costa's expression hardened. That's a policy argument, Congresswoman, not a constitutional one. The standard is whether the right itself is denied, not whether voting is equally convenient. I disagree, Your Honor, Crockett replied, her voice rising slightly but still controlled. The Supreme Court in Anderson v. Celebrezze held that burdens on voting rights must be evaluated by their character and magnitude, not solely on whether the right is eliminated. Severe burdens must be narrowly drawn to serve compelling state interests. Costa pounced. Anderson was about ballot access for candidates, not procedures for voters. True, Crockett fired back without missing a beat. But the court extended that same balancing test to restrictions on voters in Burdick v. Takushi and reaffirmed it most recently in Crawford v. Marion County. The constitutional question isn't whether the right is obliterated. It's whether the burdens imposed are justified. That principle applies here. By now, the other judges were openly studying Costa, their expressions betraying a mix of curiosity and surprise. What had begun as routine questioning had evolved into something much rarer. A battle of jurisprudence, where the witness was not merely defending, but counterpunching. Costa, perhaps realizing the exchange was slipping from his control, altered his tone again. This time it was clipped, almost dismissive. Congresswoman, with due respect to your experience as a practicing attorney, there is a difference between advocacy and constitutional analysis. States have long held broad authority over election procedures. Your legislation substitutes congressional judgment for that authority. The words hung in the air like a closing argument. The judge sounded decisive, almost final. And that's when it happened. Crockett sat up straighter, her shoulders squared, her voice dropped a note lower, steady but sharper, like steel being unsheathed. Judge Costa, she began, her gaze locking onto him. I've noticed something in your questioning. In the last 10 minutes alone, You've referenced deference to state authority no fewer than 5 times. Yet, she paused just long enough for the weight to build. In 2019, you yourself wrote passionately about. The courtroom froze. Even before the next words left her mouth, everyone knew. She was about to wield his own ruling against him. And in that instant, the balance of power shifted. The limits of that deference, Crockett finished. Costa's eyebrows arched. His voice, calm but cautious, cut through the air. I've written numerous opinions on election law, Congresswoman. You'll need to be more specific. I'm referring, Crockett replied evenly, to your concurrence in Davis v. Abbott, the case challenging early voting restrictions in 3 Texas counties. A ripple went through the gallery. Costa shifted slightly in his chair, but before he could respond, Crockett pressed on, her tone sharpening. In that concurrence, you wrote, and I quote, "While states have primary authority over election procedures, that authority is not unlimited. When restrictions create substantial disparities in ballot access that fall predictably along racial lines, courts must apply heightened scrutiny, regardless of the state's claimed interest in election administration." The silence that followed was absolute. You could hear the scratch of no pens, the shuffle of no papers. Every person in the courtroom froze. Judge Costa's expression hardened, then stilled completely as he realized she was quoting him word for word. "You continued," Crockett said, not giving him space to breathe. "The historical context of voting restrictions cannot be divorced from our constitutional analysis. Facially neutral measures that demonstrably perpetuate patterns of disenfranchisement demand judicial intervention." Costa cleared his throat, trying to steady the ground under him. "Congresswoman, that case involved specific—" "With respect, Your Honor," Crockett cut in, her voice now carrying the unmistakable edge of command. "The principles you articulated in Davis are exactly the principles embodied in this legislation. If they were constitutionally sound in 2019 when you wrote them, they remain sound today." The blow landed. Costa's lips parted as if to retort, but no words came. For the first time in years, the master of control had been cornered in his own courtroom. He attempted a quick pivot. "Congresswoman, I am familiar with my own writing. Let's move on to—" "I'm not finished, Your Honor." The words detonated across the chamber. Crockett rose slightly from her chair, the transcript of Costa's concurrence now visible in her hand. Her voice, unwavering, deliberate, carried the authority of someone who knew she had the room. "With all due respect," she continued, "you've spent 20 minutes questioning my grasp of precedent. You've claimed I misunderstand, but it is page 47 of your own ruling from 2019 that directly contradicts everything you've argued here today." Gasps. The courtroom was transfixed. Costa, who only moments before had leaned forward aggressively, now sank back into his chair. For once, the judge who had silenced so many others was silent himself. "Perhaps," Crockett said, steady and unrelenting, "we should read it aloud, so that everyone here can hear exactly what you wrote." Costa tried to rally. "Congresswoman, specific language from a concurrence addressing a particular case doesn't necessarily—" But Crockett's voice cut across his like a blade. "Your Honor, you wrote, and I quote again, 'The right to vote is fundamental not just in theory, but in practice. When practical barriers fall, disproportionately on historically marginalized communities, the Constitution demands more than deferential review, regardless of whether discrimination is explicit or implicit in the text of the law." She lowered the transcript to the table, speaking now without notes, her words flowing from memory as if seared into her mind. "You then cited Justice Kagan's dissent in Brnovich v. Democratic National Committee, where she warned that the court had damaged a statute designed to end discrimination in voting. You called her dissent prescient, and you stated, in your own concurrence, that Congress retains the authority to craft new protections addressing contemporary forms of discrimination. Her gaze locked on him. That is precisely what we've done with this legislation. Nothing more, nothing less. Exactly as you acknowledged, Congress has the power to do. The air in the courtroom had transformed. The hierarchy had inverted. What had begun as a judge interrogating a witness was now a reckoning, a federal jurist being confronted by the sharpest weapon possible, his own words, brought to life by someone who had outprepared him at every turn. And in that moment, everyone watching knew it. Costa, to his credit, didn't try to dismiss or disown his own words. Instead, after a long pause, he leaned back slightly, his expression softening, as though conceding ground he had fought hard to hold. "You've clearly read my concurrence carefully, Congresswoman," he said at last, his voice quieter now, less combative. "But there is an important difference between recognizing congressional authority in the abstract and determining whether a specific piece of legislation properly falls within that authority." Crockett inclined her head, acknowledging the nuance, but refusing to release her hold. "I agree, Your Honor. Constitutional review must always be precise and grounded in context, but that's why I find your line of questioning so difficult to reconcile. For 20 minutes, you've pressed me to defend principles that, respectfully, are not only settled law, but principles you yourself have championed. The very framework we've used in this legislation is lifted from your own jurisprudence." Her tone was calm, almost surgical, but there was a current of restrained intensity beneath it. She opened a thick folder with deliberate care, sliding several papers onto the table so they were visible to the bench. "In fact, I've gone back through your decisions. I've identified 7 separate opinions over the last decade, where you either authored or joined reasoning that aligns precisely with what we're doing here." Costa's jaw shifted slightly, but he remained silent as Crockett continued. "In Garcia v. Texas, Secretary of State, you wrote that courts cannot evaluate present restrictions without considering the historical context from which they arise. In Williams v. Louisiana Election Commission, you joined an opinion declaring that so-called neutral procedures producing statistically significant racial disparities in ballot access demand heightened judicial scrutiny. And most recently, just last year in Thompson v. Alabama, you concurred with the majority, affirming that when disparities in access are documented, the burden falls squarely on the state to justify them as necessary and narrowly tailored. With each citation, the courtroom seemed to grow heavier, quieter. Costa's posture shifted from rigid to contemplative, his eyes narrowing not in opposition but in thought. The other judges, once passive observers, now exchanged looks, some surprised, some impressed, as Crockett laid out her case with the precision of someone who had anticipated every counter before it was spoken. Finally, she closed her folder and met Costa's gaze directly. "Your Honor, the principles that form the backbone of this legislation are not speculative, nor are they novel. They are the very principles you and your colleagues have articulated from the bench for years. We have simply codified what your opinions already recognized as constitutionally sound doctrine." A silence followed, profound, stretching. For a moment, the roles in the courtroom felt reversed. The judge under scrutiny, the Congresswoman commanding the weight of precedent and logic. Costa's face, once stern and probing, now bore the thoughtful stillness of someone confronted with a reflection they could not easily dismiss. When he finally spoke, the change in tone was unmistakable. "Congresswoman Crockett," he said carefully, "you've clearly devoted significant time to studying my record on voting rights. I respect the depth of your preparation. It wasn't quite concession, but it was something rarer. Acknowledgement, recognition of equal standing. He leaned forward, his voice steady but no longer sharp. I do have further questions, but they are of a different nature. In Thompson, for instance, I raised specific concerns about the practical implementation of disparate impact standards. I'd like to hear how your legislation addresses those. And with that, the atmosphere shifted completely. What had begun as a pointed interrogation now evolved into a dialogue, an exchange not between judge and witness, but between two legal minds probing the boundaries of constitutional law. For the next 20 minutes, Costa and Crockett engaged each other with an intensity that carried no trace of hostility, only rigor. Costa asked questions that built upon her answers rather than undercutting them. Crockett responded with both legal analysis and pragmatic insight. Slowly, the other judges joined in, their inquiries flowing naturally from the foundation the two had established. The court reporter's keys clicked rapidly, capturing a moment that, as scholars would later note, transcended the usual theatrics of courtroom testimony. This was not a performance. It was a rare and genuine collision of intellects, a masterclass in constitutional dialogue unfolding in real time. One of the other judges leaned forward. Your legislation proposes new standards for evaluating disparate impact in voting access. How do you respond to critics who say such standards may be difficult for courts to apply consistently? Crockett allowed herself the faintest of smiles. That's an excellent question, Your Honor. That's an excellent question, Your Honor, Crockett replied without hesitation. Section 7 was drafted with precisely that concern in mind. The statistical measures we incorporated are not experimental. They draw directly from methodologies that have already been tested and accepted in multiple federal circuits, including the Fifth Circuit in the Vicey case. She moved seamlessly into explanation, walking the court through the statistical approaches with the confidence of someone who had lived with the material for years. She cited precedent, outlined safeguards, and demonstrated how the legislation was carefully structured to balance precision with judicial manageability. Remarkably, she did all of this without glancing at a single note. The courtroom watched, as if witnessing not testimony, but a lecture delivered with the composure of a professor before a captive audience. By the time she finished, the air in the room had shifted. What began as an adversarial inquiry had transformed into something exceedingly rare in appellate courts, a true meeting of minds. The tension of cross-examination dissolved into an atmosphere of mutual engagement, where principle took precedence over politics. As Crockett gathered her papers and prepared to leave the witness stand, Costa leaned forward slightly, his voice carrying a tone more reflective than judicial. Congresswoman, he said, regardless of how this court ultimately rules on the constitutional questions before us, I want to acknowledge your exceptional preparation and command of the relevant jurisprudence. It is a reminder of why dialogue between the legislative and judicial branches is essential to our constitutional system. Coming from Judge Costa, a figure renowned for his rigor and, at times, his unyielding skepticism, it was an extraordinary admission. Not agreement, but something rarer. Recognition. Intellectual respect. As Crockett returned to her seat, attorneys in the courtroom exchanged glances, small, silent acknowledgments that they had just witnessed something remarkable. A hearing that had threatened to collapse into hostility had instead become a moment of constitutional clarity, reshaped entirely by preparation, discipline, and the courage to engage on equal terms. The ripple spread quickly beyond the courtroom walls. Within hours, legal blogs and social media lit up with accounts of the exchange. Veteran journalist Sarah Martinez, who had been covering the federal judiciary for 2 decades, wrote, "I have never seen a witness so thoroughly prepared that they could recite a judge's own language back to him, complete with page citations. Costa is known for his intellectual firepower, but Crockett matched him point for point. Law professors across the country seized on the transcript, weaving excerpts into their courses on constitutional law, legislative process, and advocacy. What makes this interaction so valuable pedagogically, explained Professor James Williams of Georgetown Law, is that it demonstrates how thorough preparation can transform the very nature of legal discourse. Crockett didn't just defend her legislation, she established herself as an equal participant in a constitutional dialogue. For Costa, too, the hearing left an indelible mark. Observers began to notice subtle shifts in his subsequent opinions. He hadn't abandoned his judicial philosophy, but his application of it grew more consistent and more attentive to the very concerns Crockett had pressed upon him: historical context, disparate impact, and the lived reality of access to the ballot. 3 months later, in Henderson v. Mississippi, Costa authored the majority opinion upholding key provisions of state-level voting rights legislation that expanded early voting access. His reasoning echoed the very themes of that exchange: the importance of practical access, the weight of historical patterns of disenfranchisement, and the constitutional imperative to evaluate burdens not only in theory, but in practice. Judge Costa hasn't changed who he is, appellate attorney Rebecca Chon observed. What has changed is the consistency with which he applies the principles he has long endorsed. The Crockett testimony didn't alter his philosophy. It compelled him to re-examine it against his own record. And that is exactly what the constitutional dialogue is supposed to do. Good advocacy should do exactly what Crockett accomplished in that courtroom: shift the trajectory of the debate itself. For Crockett, the confrontation didn't just elevate her argument, it elevated her entire national profile. Already respected in legal circles for her years of civil rights litigation, she was suddenly recognized by millions as someone who could go head-to-head with one of the sharpest legal minds in the country and hold her ground. Requests poured into her office. Law schools invited her to keynote symposia. Legal podcasts wanted her analysis. Judicial conferences sought her perspective on advocacy and voting rights. Most importantly, she became a model. Young lawyers, especially women of color, saw in her performance not just brilliance, but a roadmap. As Maya Johnson, president of the National Black Law Students Association, put it, Congresswoman Crockett didn't just showcase technical skill. She showed how deep knowledge of precedent can force institutions to be accountable to their own principles. That's a powerful lesson for the next generation. 6 months later, the Fifth Circuit issued its ruling. In a 2-to-1 decision, with Costa writing for the majority, the court upheld most provisions of the Expanded Voting Access Act, while adding narrow guidance on implementation. Analysts immediately noticed how closely Costa's opinion tracked many of the principles Crockett had emphasized during testimony. Even more striking, the ruling established a new framework for evaluating voting rights legislation, one that gave greater weight to practical access and historical context. That framework began shaping cases across multiple circuits in the years that followed. As constitutional scholar Robert Turner observed, what's remarkable about the Costa-Crockett exchange is that it changed the trajectory of voting rights jurisprudence. We often dismiss congressional testimony as performance. This wasn't performance. It had substantive, lasting impact. The confrontation became a case study. Communication scholars dissected Crockett's style, noting how she balanced respect for judicial authority with firm, principle-driven challenge. She never made it personal, said Dr. Elizabeth Ward, professor of rhetoric at Northwestern. She anchored everything in constitutional reasoning and Costa's own jurisprudence. That made her arguments impossible to dismiss as partisan or disrespectful. Leadership consultants began incorporating the exchange into training programs on principled confrontation. Business schools taught it as an example of how to challenge authority effectively while maintaining institutional respect, a balance that's rare in any field. A year later, when Crockett and Costa shared a stage at Yale Law School, their dialogue was not adversarial, but collaborative. Costa praised her for engaging judicial reasoning on its own terms. Crockett acknowledged the essential role of judicial review, even as she pressed for a balance that allowed legislatures to meet contemporary challenges. What had begun as a clash had matured into mutual respect, a model of how two branches of government can hold each other accountable while advancing shared constitutional principles. For the public, the lesson was equally profound. In a time of shallow soundbites and performative politics, this was a glimpse of governance at its best: prepared, substantive, and principled. Political analyst Michael Brooks summed it up. What we saw wasn't just a congresswoman standing up to a judge. It was a reminder that the system works when each branch takes its responsibilities seriously and engages on constitutional grounds. Years later, as new voting rights challenges surfaced, the precedents shaped in that courtroom continued to guide outcomes. A single exchange, fueled by preparation and principle, had reshaped the legal landscape. The takeaway for citizens? In a constitutional democracy, power must always be accountable to principle. And that accountability depends on advocates who come prepared, ready to look authority in the eye and say firmly, "I'm not finished, Your Honor." If this analysis resonated with you, hit the like button and subscribe for more deep dives into the moments that shape our democracy. Share this video with anyone who values how preparation and principle can transform institutions. And tell us in the comments, what other constitutional confrontations should we unpack next? Because understanding these moments is how we move beyond political theater and see how the system really works when tested at its core.